Hi everyone, you're watching The Caffeinated Corporate Lawyer, where we try to make meaningful content to help you better understand the intricacies of corporate law. I hope you guys are heavily caffeinated because today we are going to cover Section 2 of the Companies Act 2013, which is a part of the first chapter titled Preliminary. In the span of next few short videos, we'll be taking you through some of the most important definitions which are given in Section 2. And we will try to discuss the same in depth and with as much context as we can so that you are able to grasp the concept in the best possible way. We are taking up the definition of company, body corporate, foreign company, memorandum of association, and articles of association in this video, which makes it a total of 5 definitions. At the end of the video, we will be discussing the most frequently asked definitions during job interviews and how any aspiring corporate lawyer should start preparing 1 year in advance from the time of sitting for placements. Lastly, we will discuss about the importance of understanding the legal terminologies and basic concepts and how it will give you an edge during interviews. We have provided the timeline for your convenience. So, without further ado, let's begin with Section 2. Section 2 of the Companies Act 2013 is the definition section which provides meaning of various legal terminologies that have been widely used across the Act. It contains a total of 95 clauses, as you can see in the MCA ebook, and the main purpose of this is to help us interpret all the provisions of the Act without any ambiguity. In this video, I'll be explaining all the definitions along with the concepts of company law so that we can learn while connecting the dots together about everything there is to know. I'll be discussing all this on Notion today so that it is more convenient and less of a hassle for us to understand and to keep track of all the definitions as we cover them. So switching over to Notion and starting in no particular order. So first of all, we will see the definition of company under the Companies Act 2013. Section 2 Clause 20 defines a company as company means a company incorporated under this act or under any previous company law. So what this essentially means is that a company, as per Companies Act 2013, is any company which is either incorporated under the Companies Act 2013 or any previous law. Now, what do we mean by any previous company law? So this has been defined under Clause 67, which says, previous company law means any of the laws specified below, acts relating to companies in force before the Indian Companies Act 1866, the Indian Companies Act 1866, the Indian Companies Act 1882, the Indian Companies Act 1913, the Registration of Transferred Companies Ordinance 1942, the Companies Act 1956, and with any law corresponding to any of the aforesaid acts or the ordinance in force. So what we essentially need to see is that any company which is incorporated under any of these acts, which are defined as previous company laws, which were in existence earlier, would come under the category of a company as per the definition of Companies Act 2013. So by previous law, we can also mean Companies Act 1956, which has been repealed by Companies Act 2013. So let's see, for example, Reliance Textile Industries Limited, that was incorporated back in 1985 under the Mumbai Registrar of Companies, would be defined as a company as per Companies Act 2013. So if you think about it, it makes sense because you cannot invalidate the existence of the company because of the fact that it was incorporated under an old act which stands repealed and has been replaced with a new act. Now let's take another example. BBK Electronics Corporation is a company incorporated in China and manufactures consumer electronics including smartphones. It is in fact the largest smartphone company in India at the moment and is the parent company of popular mobile brands like Vivo, Realme, OnePlus, and Oppo. Now, can we say that this is a company as per the definition of Companies Act 2013? The answer to this question is no, because it is not incorporated under the Companies Act 2013 or under any previous company law. Now, will it fall under the definition of body corporate? The answer is yes. This brings us to our next definition, that is body corporate, which is covered under Section 2 Clause 11 of the Companies Act 2013. It provides that body corporate or corporation includes a company incorporated outside India but does not include 1. A cooperative society registered under any law relating to cooperative societies, and 2. Any other body corporate not being a company as defined in this act, which the central government may, by notification, specify in this behalf. So it is pertinent to note that definition says the word includes and not means, which indicates that it is an inclusive definition and not an exhaustive one. Therefore, the intent of the Act was not to tell us what is the meaning of the term body corporate. Rather, it wants us to interpret which all entities would fall under the category of body corporate. Therefore, we can say that any entity which is incorporated as a separate legal entity under the law would definitely fall under the category of body corporate. So, what do we mean by the term separate legal entity? It means that the entity has a separate legal existence of its own, which is distinct from the members who created the entity in the first place. For example, a company is said to be a separate legal entity because it is an artificial legal person which is created by the process of law and is distinct from its members. As a result, the company can hold property in its own name, has the capacity to sue and to be sued, and has perpetual existence. Thus, the concept of separate legal entity forms the bedrock of the company law. Similarly, limited liability partnership will also fall under the category of body corporate because it is a separate legal entity. But a partnership firm, on the other hand, won't fall under the category of body corporate because it doesn't have a separate existence of its own under the law. Now, will Reliance Industries Limited fall under the category of body corporate? The answer is yes, because it is a public company incorporated under the Companies Act 2013. Now, why would the Chinese company BBK Electronics Corporation fall under this category? It is because this definition says it includes any company incorporated outside India. And BBK Electronics Corporation is a company that was incorporated in China. So effectively, it is a body corporate. Now let's shift our focus to what is not included in the definition. So clause 11 says that a cooperative society registered under any law relating to cooperative societies would be excluded. And secondly, the central government may also by notification exclude any body corporate from the definition of body corporate. However, the central government cannot exclude a company which is defined as per Companies Act 2013 from the definition of body corporate. An interesting point to note is that all companies are body corporates, but not all body corporates are companies. Why is that so? Hit us up in the comment section and tell us why do you think so. Lastly, will a foreign company fall under the definition of body corporate? The answer is yes, yet again. But how is a foreign company defined under the Act? So let's see the definition of foreign company, which is given under clause 42 of section 2 of the Companies Act 2013. It says, a foreign company means any company or body corporate incorporated outside India which A. has a place of business in India, whether by itself or through an agent, physically or through electronic mode, and B. conducts any business activity in India in any other manner. So now let's try to understand this with the help of an example. Suppose there is a company called X, which is a car manufacturing company incorporated in US in 2011 and which is not conducting any form of business activity in India at the moment. Now, as per the definition of foreign company, X would be treated as a body corporate and would not satisfy the meaning as defined in Companies Act as a foreign company. Now let's assume X opens up a branch office in India and starts selling cars within India. Now we can say that X is a foreign company. Now, if we shift our focus back to the definition of foreign company and break it up into two parts, we can see that first of all, a foreign company necessarily has to be a company or a body corporate incorporated outside India, with the added condition which is given in the second part that says that it should have a place of business in India and should have some form of business activity. Now, do you think if Space Exploration Technologies Corporation or SpaceX, which is an American aerospace manufacturing and space transportation services company, would be treated as a foreign company as per the definition of Companies Act 2013? Hit us up in the comment section with your answers and let us know what you think about it. Next up is the definition of Memorandum of Association. Section 2, Clause 56 of the Companies Act 2013 defines memorandum, which means the memorandum of association of a company as originally framed or as altered from time to time in pursuance of any previous company law or of this act. Now, very little can be understood from the definition as provided by the act. So let's see the concept of memorandum and then come back to the definition as stated in the act. So Memorandum of Association is basically the main charter document of the company because of the fact that it contains the main object for which the company was incorporated in the first place. It defines all the possible scope of operations of the company and defines the powers as well as confines the powers of the company. Think it of as the constitution of the company. It contains the fundamental conditions upon which a company is incorporated. In fact, the first and foremost step of formation of a company is the preparation of the Memorandum of Association by the promoters of the company. Now, the main thing to remember is that it is this piece of document that provides what all activities can be undertaken by the company and thus forms the ambit within which a company would operate. The main key clauses which the Memorandum of Association contains are name clause, registered office clause, objects clause, liability clause, capital clause, subscription clause, and succession clause applicable in case of one-person companies. We will discuss it more comprehensively when we tackle the sections related to Memorandum of Association later on. Now, if you look back at the definition, it means to say that memorandum is the Memorandum of Association which was originally framed, which means memorandum as was framed and submitted by the promoters of the company with the ROC for the formation of the company. Now, the second part says that it is also the altered memorandum, which means that there can be a scenario where the company might have amended its Memorandum of Association subject to fulfillment of certain conditions, which we will again cover in the upcoming videos as and when we deal with those sections. For instance, the company decides to change its name from A Private Limited to Z Private Limited and is successful in doing so. Then it will have to amend its registered name clause of Memorandum of Association, and such an altered Memorandum of Association would also continue to be defined as the Memorandum of Association of the company as per the definition of the Companies Act 2013. Now, let's see the second charter document of the company, which is the Articles of Association. Section 2 Clause 5 defines the Articles of Association of the company. The articles means the Articles of Association of a company as originally framed or as altered from time to time or applied in pursuance of any previous company law or of this act. Again, this is a very crude definition. If you think of Memorandum of Association as what, then think of Articles of Association as how. Articles of Association are basically the bylaws or the rules and regulations of the company regarding how the company would manage its internal affairs and conduct its business. So, it lays down the procedure which has to be followed by the company in order to execute its powers or functions, thus setting out the manner in which the administration of the company will take place. For example, the Articles of Association would set the ground rules as to the procedure of transfer of shares of the company from the transferor to the transferee. So, while the Memorandum of Association defines the company, the reason for its incorporation, and defines and confines the activities which can be undertaken by it, the Articles of Association, on the other hand, regulates and sets the manner in which those objects would be achieved and how the powers of the company would be exercised. Another important point to remember is that the Memorandum of Association has to be made subject to the provisions of the Companies Act 2013. What this means essentially is that none of the clauses of the Memorandum of Association can be contrary to the provisions of the Companies Act 2013, since the Act would always prevail over the Memorandum of Association. Similarly, if there are any articles of Association which are contrary to the Memorandum of Association, then Memorandum of Association will always prevail. So if you see the hierarchy, the Act would always prevail over the Memorandum of Association, and Memorandum of Association will always prevail over Articles of Association. Thus, by theory of transitivity, the Companies Act 2013 will always prevail over Articles of Association. On that note, hit us up in the comment section if you remember what is the theory of transitivity. We will talk about Memorandum of Association and Articles of Association and its related provisions in depth when we come across those sections. Coming to the second part of the video regarding interview preparations. The main reason as to why we are discussing all the important definitions is because when you guys sit for your placements or job interviews, then you will be tested during the interview with the basic concepts and definitions. We generally encourage and advise aspiring corporate lawyers to start preparing for their placements or interviews at least 12 months in advance, from the week of your placements. This is a universal advice, and we are assuming the worst case scenario that you are at point zero in terms of your preparation. First and foremost, we would advise you to start 12 months in advance, and during these 12 months, your aim should be to finish 3 subjects in depth, which are Companies Act 2013, Contract Act 1872, and Transfer of Property Act 1872, besides brushing up on all the work that you have mentioned in your CV. In all law firm interviews, you are expected to have absolute clarity on these 3 subjects if you are aiming to break into the general corporate team or the mergers and acquisition team, or in general in the non-litigation part of the law firm. Additionally, you will be required to know SEBI listing obligations and disclosure requirements, and SEBI issue of capital and disclosure requirements if you are going to get into the capital markets team. My point being that you should be thorough with the subjects that are associated with your preferred practice area of interest. For instance, you cannot say that your strength lies in constitution law when you are sitting for a job interview for the general corporate team. Second key point, consider preparing for your job interview as if you are writing your statement of purpose, and you should ideally be able to construct a story and convince as to why you are interested in a particular practice area of law and what are the qualities which sets you apart from others. And it is equally important that your story resonates with the content of your CV. Also, make sure that your CV is written in a concise manner. You will lose on some brownie points if you can't explain the work that you have done and are unable to answer in context of the research work. Think of it as the syllabus which you are anticipating to come in the exam with absolute certainty. It would be a cardinal sin if you don't cash in on this opportunity. But having said that, there is no straitjacket formula to clear every law firm interview because each interview is different from the last one. Certain law firms would disregard your CV and will first test you on the basics of the law. They will ideally judge you on your presence of mind and attitude during the interview while answering to their questions, and most importantly, with how much clarity you can answer the questions posed before you. Third key point to remember is giving as many mock interviews as you can. It is an absolute prerequisite that you give as many mock interviews as you can with the help of seniors at your law school or with the assistance of any legal professional with relevant experience with whom you have connected very well, or with the assistance of your mentor. You can practice with your classmates as well, but they might not be able to catch the errors and mistakes that you are making. Also, work on your introduction because yes, first impressions do matter. You don't want to get overwhelmed by the gravity of the situation when you enter the conference room for the interview and sound weak and squeaky during your first introduction. Remember, the golden rule, you should be oozing confidence but not so much as to spill in the form of arrogance. That comes from giving mock interviews. Also, you should be well dressed in formals. Now, when you mention why law, why incline towards one practice area of law, be ready to face questions on it as well. For instance, if you say that your core area of interest is mergers and acquisition, then you should be able to answer as to how a merger is different from an acquisition. Or if you have worked on a due diligence, then you should be able to explain what is due diligence as well as its purpose. It is of paramount importance that you know all the concepts and legal terms by heart. By that we don't mean to cram it up, but to be able to apply those concepts to answer questions asked during the interview. Before I tell you which are the most frequently asked definitions and concepts, an important disclaimer. This is by no means an exhaustive list. I repeat that this is not an exhaustive list and is simply to give you an idea as to how you should prepare for that coveted job and start well in advance. The earlier you start, the better it is. Now, some of the frequently asked definitions / concepts which should be dancing in front of your eyes at all times are the definition of private company, public company, the difference between private and public company, holding company, subsidiary company, wholly owned subsidiary company, related party, government company, what is a share, what is an equity share, what is a preference share, what is the difference between equity and preference share, what is a non-banking financial company, what is the charge, hypothecation, mortgage, types of mortgage, pledge, agreement, contract, what is the difference between agreement and contract, what is a prospectus, what is a red herring prospectus, what is an abridged prospectus, what is merger, what is acquisition, what is demerger, what is the meaning of control, what is creeping acquisition, what is listed company, what is debenture, what is lease, what is license, what is the difference between lease and license, who is a promoter, what is a promoter, what is the difference between member and shareholder, what is rights issue, what is ROFR, what is ROFO, and what is the difference between them, what is a small company, what is a startup company. Basically, all the key definitions which can be possibly asked depending on the nature of work that you have done. So for instance, if you have worked extensively on matters relating to abuse of dominant position in competition law, then you should be able to answer basic questions like meaning of dominant position, relevant market, what are the list of activities that would fall under the ambit of abuse of dominance, what is predatory pricing, and even better if you can explain all these concepts with the help of a case law. Now, you cannot possibly wait for a week to start your preparation. Disregard the fact that you might be in the top 10 of your batch when it comes to scoring marks. That would be of no consequence if you won't be able to answer the basics of law. You might argue that we have seen X or Y person ace an interview without significant preparation. To reiterate what we said before, we can't possibly factor in everything and tell a tailor-made plan for each and every law student until we interact with them on a one-to-one basis. So you are the best judge of where you stand, and it's up to you at the end of the day to grab all those opportunities and make the best out of it. This 12 months preemptive strategy is a universal one, and we believe that 12 months of dedicated focus is the perfect blueprint for acing not only job interviews but also in training yourself for what lies ahead when you start your corporate law firm job. Now, why 12 months and not 6 months? It is because you can't possibly anticipate the workload you might face in the course of last 2 semesters or last 4 semesters. You would be juggling possible assessment internships and studying for your end semester examinations as well. Lastly, to refute that argument that few people clear the job interviews easily, you have to take into account other factors as well, like their public speaking skills. Perhaps they were into debating while in school, and they have had plenty of opportunities to be in such kind of situations from where they got the much needed experience as to how to give an interview. There are innumerable reasons as to why X person can be at a significantly better position than Y person when it comes to clearing interviews, which can be attributed to their educational background, the kind of environment they have been brought up, and their life experiences. Lastly, we hope that whichever position you might be in, you follow our advice and keep ahead of the curve by starting your preparations well in advance. And by well in advance, we mean 12 months in advance. That's all from this video. Hit us up in the comment section or email us if you have any queries. We'll catch you in the next one. Thanks.